The views expressed are not those of local community broadcasting, WYML LP, or its management, volunteers, or underwriters. Greetings and welcome back to the Personal Safety Show. This is Marcus Melnick, your host of Firearm Mentor, and we have a great episode lined up for you today. We will be interviewing a gentleman who's running for Illinois State Representative in the 59th District. However, before we do that, I'd like to give some updates on some things that are happening in the firearms industry and self-defense things. So, first of all, our first episode interviewed a citizen who was at the Highland Park shooting a year and a half ago on the July 4th date, and the father of the shooter was charged with whatever felony he was charged with because he signed off on his son getting a FOID card. His son later on conducted a mass shooting. So earlier this week, on Monday, this father, who was the father of an Illinois man accused of killing 7 people during the Independence Day Parade, pled guilty to, quote, reckless conduct for helping his son obtain the assault rifle used in the mass shooting. Robert Cremo Jr. of Highland Park had been set to go on trial Monday in a rare case where the parent who was being held criminally responsible for the actions of their child. Cremo Jr. entered a plea with prosecutors hours before the trial was set to begin. He pled guilty to 7 misdemeanor counts of reckless conduct for helping his son obtain a state firearms permit, even though he had a history of mental illness. The sentence was 60 days in jail, 2 years of probation, and 100 hours of community service. The shooter was 19 at the time the gun was bought and needed his father's sponsorship to get an Illinois FOID card. Okay, now I get it. I previously said that I don't think the father was criminally liable because I don't know when the rifle was purchased. And Cremo III, the shooter, he was over the age of 21. So very possible he could have bought it after the age of 21. But according to this article on Yahoo News, he was 19 when he got the AR-15. The shooter is expected to go on trial for murder, attempted murder, and related charges. And amid a huge number of deadly firearm incidents, pressure has been mounting to punish parents who make it possible for their children to get weapons. For example, the children of a 15-year-old boy who killed 4 people at a school in Oakland County, Michigan in November 21 has been charged for buying their son a gun, even though they were aware of troubling signs he was a threat. So let me talk about buying guns for youth. Because when I was growing up, and it was a different world back then than it is now, I totally understand that. But when I was growing up, I was 7 years old when my father taught me how to shoot. And when I turned, I want to say 11, maybe 12, I was in 6th grade. I got on the honor roll, and the gift for me getting on the honor roll was a firearm. Now, my parents did it the right way. All this was a feel-good. In other words, I had my own gun in 6th grade, but I never had access to it. We would go to the range. My father would open his briefcase, hand me, I'm making air quotes, my gun. I would shoot my gun and give it back to him. And he'd put it in his briefcase. He'd go home and it would get locked up. When it was time to clean the gun, because he made me clean the guns, he would take it out of the lock container, give it to me. I didn't even know where the lock container was. It was not only locked, but hidden as well. I never had access to it. Then I would clean it, and then he would tell me, not good enough, do it again, and then I had to clean it a second time. But I certainly learned how to clean firearms. With that said, the family in Michigan bought their 15-year-old, I believe he was a sophomore at the time, a SIG 9mm, and let him have access to it. And here he did a school shooting. So in a lot of ways, parents can be responsible for their children's behavior. All right, let's switch gears. According to the Lake and McHenry County Scanner website, federal appeals court upheld Illinois' assault weapons high-capacity magazine ban. This stinks. So a federal appeals judge last Friday, so it would be a week ago Friday, upheld the assault weapons and high-capacity magazine ban in Illinois, rejecting a Second Amendment violation argument. The ruling came as plaintiffs who were challenging the Illinois gun ban were back in the Southern District with an amended complaint to block the January 1st gun registry deadline as public comments about the rules continue. The Seventh Circuit U.S. Court of Appeals heard the Second Amendment challenge of the Illinois gun and magazine ban in late June, and on Friday, the three-judge panel issued an opinion. The prevailing judges, the ones who supported the assault weapons ban, were quoted as saying, finally, we have no need to decide whether an alleged Second Amendment violation gives rise to the presumption of irreparable harm, and if so, whether such presumption is rebuttable or ironclad. Okay, that's legal mumbo-jumbo, but the lay term is we didn't win. Given our decision that the plaintiffs have not shown that they have strong likelihood of success on the merits, we think it is best to save this point for another day. We also have no comment on the other two parts of the winter inquiry, where the balance of equities lie and what the public interest dictates, the judges said. Judges Frank Easterbrook and Diane Wood issued the prevailing decision. Of course, Governor Pritzker praised the decision. Despite constant attacks by the gun lobby that puts ideology over people's lives, here in Illinois, we have stood up and said no more to weapons of war on the street, Pritzker said. Now Congress must act so Illinois is not an island surrounded by states with weak protections. Okay, what a bunch of hooey. First of all, an AR-15 is not a weapon of war. I know I'm preaching to the choir here. It was developed as a sporting rifle and later adopted and changed to the M16, now the M4, for military service. The quality of the parts is different. The specs are different. The outside dimensions and the appearance may look the same, but it is a different type of firearm. The dissenting judge, Michael Brennan, Judge Michael Brennan dissented from the appeals decision. Judge Michael Brennan dissented from the appeals court majority decision. He said the banned magazines are arms, as are other appliances, such as a pistol grip and a flash suppressor. The Southern District of Illinois Court correctly read Heller and Bruin to locate in common use in Bruin's history, and tradition applied the how and the why test to conclude that concealed carry regulation differs from a ban on possession and does not pass a historical analog. This led to the Southern District Court to, quote, correctly issue an injunction against the act. Appeal to the U.S. Supreme Court is expected and cannot come too soon. Part of the Protect Illinois Communities Act, Pritzker enacted on January 10th, requires grandfathered firearms to be registered. We have an entire episode on that. If you go on our YouTube page, look up Firearm Mentor, you can search for it and find out what is actually banned. The ISP in early October opened the registry for those with banned firearms, and disclosures are required by January 1, 2024, with criminal penalties applying to those found out of compliance. After the registry opened, plaintiffs represented by attorney Thomas Magg brought their vagueness challenge out of the consolidated cases in the appeals court. Oral arguments were last month in front of a Southern District of Illinois federal judge, Stephen McGlynn, and a ruling is still pending. Separately, Thursday, federal firearms licensees of Illinois were granted a motion by McGlynn to amend their complaint, which is good. The FFL of Illinois is seeking the state's gun ban registry to be delayed beyond January 1st until these court cases are heard. They say otherwise, countless people who lawfully purchase firearms will be turned into criminals overnight at the end of the year. Happy New Year to everyone. That was my comment. Or forced to forfeit their firearms. The state cannot meet its burden to defend such an outcome under Supreme Court precedent. Their complaint argued that the emergency rules of the Illinois State Police filed for the gun ban registry are inadequate and do not provide proper due process, violating not just the Second Amendment, but the 14th Amendment as well. Emergency rules only allowed when there is a threat to public interest, safety, or welfare, which requires rules to be adopted in less time that would be needed to complete the proposed rulemaking. Why the Illinois State Police waited over 9 months from when the Firearms Ban Act was adopted to file emergency rules rather than making proposed rules under the normal process earlier is not explained. FFL of Illinois also argues insufficient notice is being provided. I can actually speak to that because I had a concealed carry class last weekend, and one of the people in the class was saying, how is this being disseminated? He had no idea that there was this ban in place. Well, he got educated in the class. The complaint further says Illinois could have easily provided direct notice of the registration requirement to all FOID holders because it has all their contact information. Yeah, guess what? The state might have to actually send out a letter or an email. McGlynn gave the state until January 31st of 2024 to respond to this amended complaint, which is after the registration deadline. A forthcoming motion for the preliminary injunction is expected before January 1st. Attorneys representing the state defending the gun ban said Wednesday in court that the FFL plaintiffs agree and do not object to the state defendants having up to and included December 1st, 23, to respond to the forthcoming second preliminary injunction motion, which the plaintiffs agree to file no later than November 3rd. It's after November 3rd. I have not heard anything. In the meantime, ISP has been holding public hearings. You can go on their website. I believe it's on YouTube as well. You can listen to it. Some of the hearings have good questions, but there was a lot of deflections. And the hearings came after the Joint Committee on Administrative Rules approved a motion recommending 3 public hearings. First hearing was in Springfield. There was one in Chicago, and there was another one, I believe it was downstate. And there's been a lot of people complaining that, what about the Chicago suburbs? What about northwest part of the state? What about the southeast part of the state? 3 hearings, although you can access them online and you could submit, I don't think are sufficient. So the hearing in Chicago included members who supported the measure, like Kathleen Sanses, president of the Illinois Gun Violence PAC. She said opponents of the law are tying up the courts with their challenges. Well, that's what we're supposed to do, is we're supposed to challenge unconstitutional laws. Enough with the circular debates, the wasteful use of our court systems and other tactics to appease egos and pockets. Let public safety be something we can all get behind, and let it not be a matter that remains open for compromise. Really? Yet the same party passed the Protect Illinois Act, which allows alleged felons out of prison pending trial. Other questions, ISP officials referred to the FAQ guidelines on their website, and our friend, gun rights advocate Todd Vandermite, said that it's not helpful for gun owners facing possible enforcement of rules that he says are too vague, and I agree. You may beat the rap, you ain't going to beat the ride, Vandermite told ISP officials, and that's why I think you have a big problem here, because you haven't defined readily restored, you haven't defined readily convertible, or what any of that means. So after Thursday's hearing in Springfield, State Rep Amy Elick, she's a Republican, said that she expects the law to be struck down by courts. Thank God. In the meantime, she encourages people to file public comments about the gun ban registry by the November 20th guideline. You can go to the Illinois State Police website and find out how to do that. Having hearings like this in the middle of the day is difficult for people to take off work in the short notice that we have been given. So I'd say definitely go on and submit your testimony. And that's a comment from Elick to the Center Square. So as you can see, folks, it looks like, although I'm hopeful it doesn't, it looks like the assault weapons ban and the magazine ban is here to stay. And what we are supposed to do as citizens, if we own one of these banned items, is either, number 1, register them, number 2, move them out of state. You have a friend in a neighboring state that can store them for you, at least until the courts are all worked out. And the reality is the compliance rate is so low that it's going to be very difficult to enforce. In my opinion, it will be enforced as an additional charge, meaning somebody uses an AR-15, say in a mass shooting, and it's a banned item, or any banned item, doesn't have to be an AR-15, they will be charged with the shooting, they will be charged with murder, They'll be charged with whatever else they're going to be charged with. And then the felony of possessing a non-registered firearm, if it is non-registered, will be a tack on charge. Hope this entertained you a little bit. Hope this educated you. We are going to be talking with Chris Henning, who is running for office, coming up next. Chris Henning is running for the 59th Representative District in Illinois. It is a seat currently held by Democrat Dan Dedich. And Chris's background is he's a vet. I don't mean like a take care of animals vet. I mean a veteran. He's lives in Mundelein, active member of the community, been an attorney since just around the turn of the century, and has taught business law and criminal justice at the college level. Chris, thank you very much for taking the time to talk to our listeners about your campaign, your viewpoint, and your work.
Oh, thank you very much for having me. It's a pleasure to be given this opportunity to speak.
Awesome. Can you tell everyone, how did you get to your current point in life? What is your origin story? How did you evolve into deciding to run for office?
I grew up in the northwest suburbs, originally Hoffman Estates, and then moved to Arlington Heights. I attended St. Viator's High School locally in Arlington Heights. Upon graduation, I went up to the University of St. Thomas in St. Paul, Minnesota. Graduated with a bachelor's degree, majoring in history. During that time, I also spent a year studying abroad at Trinity College in Carmarthen, Devon, in South Wales.
Did you have to learn the language?
No, it's
I'm kidding. It's English.
It's actually a very beautiful language to listen to.
Yes.
At times, I would almost be hypnotized, depending on where in Wales. And if you're familiar with Wales or Scotland or the rest of the UK, the way that the different accents change regionally, it's amazing. And there's so much difference, so much distinction between the various areas. But some of them was so rhythmic, you'd almost fall asleep, you'd be hypnotized. And just an amazingly beautiful language to listen to.
I was making a little sarcastic joke. Sorry. I didn't mean to throw you off. All right, so you went overseas, did some overseas in Wales and Scotland. Please continue on.
After graduation, I ended up going and testing for and being hired by the Elk Grove Police Department. It was not the fit for me. I did not feel at that point that the village had the backs of the police. We had one Saturday shift, for example, and a candidate, I believe it was a candidate looking to run for a village office, had posted signs on the parkways and where people place signs.
Mm-hmm.
And was instructed by the village that was against the law. It's against our village ordinance. And I said, well, you let all these other signs go up there. We spent an entire Saturday shift filling the trunk of our squad car with all the signs off of the power poles, off of the parkways, any other property that was designated they couldn't be posted on. You ended the shift on a Saturday, throwing it all in the dumpster. I also recall when leaving that day, seeing the shift sergeant in the dumpster recovering people's signs for it. It left a very bad taste. Also at that time, Cook County Jail was under a consent decree due to overcrowding. And similar to what we now are going to start seeing, I suspect, people were being I-bonded out when they got to the county jail. There it wasn't everybody. It wasn't obviously statewide. But if I recall the specifics, if you were at Cook County and your bail was under $50,000 and you weren't there for a violent felony, you were getting I-bonded out. And much like the information from Elk Grove, you can go back to the old Herald stories from about 1990, and you should be able to find some of the stories because they were threatening all of the village employees that if they didn't, if they passed any of these signs, they would be given a day off without pay.
Ugh. For doing their job.
Well, for passing a sign on the parkways and not either asking the person to remove it or not removing it themselves.
Okay.
But were you to go back to the issues with Cook County, you can go back to the Chicago Tribune, and there's an article published September 2nd, 1990, No Cash Bond Leads to Increase in Crime, which really, if you think about it, is a no-brainer. The issue you have as a police officer or law enforcement is to create compliance with the laws. Police officers' ultimate authority is to restrict or take away an individual's freedoms to the ultimate level if the circumstances rose that high. When you look at it, if you take away that restriction of freedom, where is the deterrent?
Yes.
You lose the deterrent in the process. What you see is large numbers of recidivists. Most citizens aren't having several interactions with the police where it's an issue. The larger problem comes from the recidivists. And when those recidivists being repeat offenders, those that continue to commit the crimes, and when they know there's no longer a deterrent that they're not going to lose their freedoms, they will continue to commit more crimes.
I'm going to jump around a little bit. You kind of alluded to the Safety Act, and I know the Safety Act came into being last year. It was there was a stay with the Supreme Court, and ultimately over the summer, the Supremes in Illinois decided that it is perfectly constitutional and was implemented, I believe, September 17th. I know, because I used to work in law enforcement as well, several people who are still active police officers who have told me story after story of people being released, and I mean for violent crime. One particular case, it's still ongoing, but the guy took 3 shots at his ex-girlfriend with bullet holes, and they recovered stuff. So there's a lot of evidence there. He just hasn't gone to trial. He's out. It's just ridiculous. Do you think that the Safety Act, and maybe I'm beating a dead horse, but do you think that the Safety Act is here to stay, or do you think there may be a realization that, holy cow, we just created this abyss of crime?
I would seriously hope that elements of the Safety Act are looked at again. But as I said, the no cash bail will be problematic. Difference again being now it's all criminals throughout the entire state. Back in 1990, we just had Cook County Jail,
Which was almost every crime in the state. I'm being facetious here.
If you've been in law enforcement, if you've served in the military, dark humor is a very common way that people have learned to cope with situations that otherwise might not be that pleasant. Back then, to quote from the Tribune, by the end of February 1990, 1,559 of the defendants, 25%, had been arrested again on at least one new charge, according to the records. In addition, nearly 35%, 2,138 of the defendants jumped bond and didn't appear at the first court hearing after their release from jail, according to the records. That's another element of the Safety Act, which really presents a problematic issue for public safety, because we no longer have the failure to appear warrants going out when the people skip their court hearings. You see time and again reports of people out with electronic monitors. They're wearing the monitor and getting arrested for crimes.
Right. Right.
It's ridiculous. I fear that what may trigger repeals of portions of that act, we may run into a circumstance where you have criminals released, commit some very heinous crimes, and the citizens saying enough is enough.
I don't wish harm upon anyone, but it's very interesting, and this is, I'm giving you my opinion. Why did we have an assault? I'm switching gears a little bit, but it'll all come back. Why did we have an assault weapons ban? Because there were politicians at the parade who were directly affected. That's the reason. And that's my opinion. It's not because regular citizens got hurt, although, there's always hope and prayers for them as well. But they took action because they were in the line of fire. And unfortunately, I hope that doesn't have to come to that, but it might. It might have to come to one of the elected officials having a member of the family involved in some nefarious activities. And I hate to say that, but I think that's what's going to initiate change.
My belief and understanding is people in Springfield had wanted this ban prior to that. But that being said, is it reasonable to assume that momentum increased because of those circumstances you described? I would say it's definitely not unreasonable to make that sort of read based on the timing and the rhetoric surrounding the passage of the ban.
So before I get into your work in teaching on the college level, I just kind of want to make a little comment that when I saw you went to University of St. Thomas, I kind of got excited. Oh, beaches, and because I'm thinking in the Caribbean. You went to St. Thomas, Minnesota, where the climate is just a slightly little bit different. So I was kind of laughing to myself at that. I imagined the wrong St. Thomas. But you've done work as an adjunct professor with Columbia and CLC. Can you tell our listeners what you taught, what you did in those experiences?
When I was teaching at Columbia College of Missouri, which has a satellite campus up in Gurnee, that college, it has a great relationship amongst military, and they have a number of satellite campuses near military installations, in this case, Great Lakes. I was teaching business law, which is, a nice sort of generalist look at law from the 10,000-foot, as they say, perspective. Requirements in contract law. What is a tort?
Right.
What constitutes negligence? A little touch of criminal law, a little touch of real estate law, just so that people can, again, have sort of that generalized view of an understanding as they are going for, in this case, targeted towards business students. At CLC, I taught a section of criminal justice. And with my background, as I had said earlier, I had been a police officer, and I did the opposite of most people. I went into the Army after leaving the police.
Oh, interesting. I didn't realize that.
So in doing that, I entered, and I was a legal specialist with the 1st Cavalry Division down at Fort Hood. The legal specialist, now I believe they title it paralegal specialist, largely works on, especially at the battalion, the brigade level, are court-martials, non-judicial punishment under Article 15 UCMJ, which is quasi-criminal, enlisted separations, largely, at least a significant portion, being for misconduct. You do congressional inquiries.
The views expressed are not those of local community broadcasting, WYML LP, or its management, volunteers, or underwriters.